The Hawaii bar exam is administered on the last Tuesday and Wednesday of February and July. The exam has two sections, the written exam and the MBE. The written exam given on Tuesday consists of the Multi-State Essay Exam, or MEE, and the Multi-State Performance Test, or MPT. The Multi-State Bar Exam, or MBE, is given on Wednesday. There is also a separate Hawaii legal ethics portion of the exam that is administered on Tuesday. It consists of 15 multiple-choice questions testing the Hawaii rules of professional conduct. You are given 30 minutes to answer the 15 questions. Each section of the Hawaii bar exam is given equal weight for scoring. The Hawaii bar examiners do not release scores to successful applicants. Therefore, no minimum passing score is available. The first day of the exam consists of 6 MEE questions, 2 MPT questions, and the Hawaii Professional Responsibility Exam. On Tuesday, the first day of the bar exam, you will take the Multi-State Essay Exam, which is more commonly known as the MEE. 6 MEE questions are administered during a 3-hour session, which is usually given in the morning. On average, you have 30 minutes to answer each question. Areas of law that may be tested on the MEE include business associations, including agency, partnership, corporations, and limited liability companies, conflict of laws, which will not be the main subject tested in a question. It could be a side issue for a question testing another subject. Family law, trusts, and estates, which includes trusts, wills, and decedents' estates in general. The Uniform Commercial Code, or UCC, including the law governing secured transactions. All of the MBE subjects may also be tested on the MEE. These are civil procedure, constitutional law, contracts, which include sales, governed by Article 2 of the UCC, criminal law and procedure, evidence, real property, torts. Most MEE questions test just one subject of law. However, some MEE questions may include questions testing more than one area of law. As I mentioned a moment ago, conflict of laws will not be the main tested subject of an MEE question, but related issues may arise in a question testing another subject, most often civil procedure and family law. The Multi-State Performance Test, which is more commonly known as the MPT, will also be administered on Tuesday. The MPT consists of 2 90-minute test questions for a total duration of 3 hours. The MPT is a closed universe test, which means that the examiners will provide you with all of the materials you need in order to adequately answer the question. This includes both the facts and the laws that you must apply in order to properly address the questions. If you find yourself going outside of the information contained in the file and library to the knowledge of legal principles you have learned to prepare for the bar exam or in law school, then you are doing something wrong on the MPT. All the law you need to know in order to answer each question is contained in the library section of the question materials. The MPT presents real-world lawyering situations. It tests skills commonly used by lawyers. For example, you may be asked to assume the role of a junior associate at a law firm or a new attorney working for the district attorney's office. As a new attorney or junior associate, you may be provided with a task memo by a superior directing you to write either an objective or a persuasive memorandum. These are the 2 most common types of MPT questions, and what you will likely encounter on your exam. 1 question calling for an objective analysis, and 1 question calling for a persuasive analysis. In a typical MPT question calling for an objective analysis of legal issues, you may be given an assignment and asked to determine whether your client is likely to prevail on a particular case. In a typical MPT question, calling for a persuasive answer, you may be required to write a memorandum to a court or perhaps a letter to opposing counsel. You can maximize your score on the MPT if you do 6 things well. Number 1, you should be able to sort detailed factual materials and separate relevant from irrelevant facts. You'll be given a very large case file that will contain the facts of the case. You have to be able to work through the file and identify facts that are relevant and address them in your answer. Number 2, you must be able to analyze statutory, case, and administrative materials for relevant principles of law. In addition to the file, you will be provided with a library. The library contains the relevant and irrelevant law that you must sort through. It will contain different types of legal authority, such as statutes, cases, secondary authority, and more. You must be able to identify the important legal authority that will apply to your question. Number 3, you must be able to demonstrate legal analysis. In other words, you must be able to apply the relevant law to the relevant facts in a manner likely to resolve the client's problem or argue in favor of your client's position. Number 4, you must be able to identify and resolve ethical dilemmas. If you see an ethics rule in your library, it is very likely that it may apply to your case. If you can identify the ethical dilemma and resolve the issue, you will get more points. Number 5, you must be able to communicate effectively in writing. Do you know how to write objectively and how to write persuasively? If you don't, you must learn the difference. And number 6, can you complete a lawyering task within time constraints? You will always be rushed on the MPT. Can you finish addressing the question in the time allotted? If you can finish addressing all of the questions and issues in your MPT question, you will maximize your score. Once again, for most MPT questions, you will be required to write either an objective or persuasive document. This may include a memorandum to a supervising attorney or to opposing counsel, a letter to a client, a persuasive memorandum or brief, or a statement of facts. Less frequently, you might be required to draft a contract provision, a will, a counseling plan, a proposal for settlement or agreement, a discovery plan, a witness examination plan, or a closing argument. Regardless of what type of document you will be required to write, keep in mind that usually you will be given explicit directions and you will be expected to follow them. If you answer your question according to the instructions you are provided with, you will maximize your score. If you do not follow the instructions, for example, if you address an issue you have been directed to ignore, you will lose points. On Wednesday, the Multi-State Bar Examination, or MBE, is administered. The MBE is drafted by the National Conference of Bar Examiners, not the local bar examiners. It's administered in almost every state and federal territory. The MBE is a 200-question, multiple-choice exam that tests several different subject areas. The subjects tested on the MBE include civil procedure, contracts, which also includes sales, torts, constitutional law, criminal law and procedure, evidence, and real property. As with the MEE, MBE questions should be answered according to majority legal principles and the federal rules of evidence and procedure. The MBE is split into 2 sessions, morning and afternoon. Each session consists of 100 questions, for a total of 200 questions. Of the 200 questions, 190 questions count toward your MBE score. The amount of questions you answer correctly is called your raw score. Your raw score is then adjusted into a scaled score. Scaling varies depending upon the difficulty of the exam, but can range anywhere from 5 to 30 points and may even occasionally fall outside this range. One thing you need to know about the MBE is that the MBE is an objective type test, and because of that, the examiners can test from all over the scope of testability, which is a little different from the essay portion of the exam. On the essay exam, the examiners tend to test fundamental legal principles and avoid testing obscure points of law. On the multi-state bar exam, there will be a greater scope of testing just by virtue of the fact that this is an objective style test.